The next one is the Bombay High Court judgment, which my management had relied upon.
तो सर दे दिया, फिर आप एक एक करके क्यों दे?
Oh, मेरा पैराग्राफ से नहीं मिला है इसलिए दे दिया।
टपरिया ना
मतलब the page number this judgment is page number 80. It minus 6, page number 80. But the pagination is on top.
पैरा नंबर बोलिए मेरे को।
Yes.
But page 80, page 5 to 45. The bigger portion. In case at hand, this is not in dispute. The petitioners had obtained license for valuable consideration without the notice of any fraud, alleged to have been committed by the original while granting license. If that be so, the concept that fraud issues would not be applicable to a case where the transaction of transfer of license for a value without notice arising a market transaction. Again, my lord, it's not a case of fraud. The last one, the Supreme Court judgment was.
Mr. Kanwadia, your judgments were all compiled or they are with the petition?
Lordship, in petition somewhere there are others which I had given separately. Lordship, maybe I will give a compilation of writ petition also.
No. I'll just
No.
arrange it.
Because mostly, Lordship, it was in the writ petition. Some judgment like National Plasto and Asian Hotels, these were given
handed up separate.
Lordship, because if Lordship requires, I can prepare a small compilation.
No. Why should I unnecessarily burden you?
No, for their convenience.
One jungle has gone.
No.
One jungle is there for the paper. No, I have also contributed.
Yes.
25%.
But the last is the Shantikir on India ballot, which my management has relied upon.
Just a minute, Mr. Chakravarti. 1 minute. Yes, Shanti Kiran, unreported judgment was given.
Yes, Lordship.
My Shantikir now is reported, subject to 2025, volume 147 GSTR.
Then this Telangana High Court was also given.
So were all these judgments?
Telangana High Court who gave?
Lordship.
You gave?
I have not.
Venkataramana Reddy.
No, Lordship.
It is an income tax. It is ভিতরে রেখেছেন কেন?
I am not.
এটা এর জাজমেন্ট তো নয়। দেখতে হবে। ভুলভাল জাজমেন্ট লেখা আছে।
I had given Allahabad High Court single iron trader, Lordships.
Just a minute. Roshan Sharma is there.
Roshan Sharma.
Krishna Wax, Mr. Chakravarti had given. দিদি এখানে আরো জাজমেন্ট ছিল তো বাকিগুলো কোথায় গেল? বার না করলে তো আমিও তো বার করবো, সুতো দিয়ে বাঁধা আছে, বাকিগুলো কোথায় গেল? এই জন্য বারবার বলি একটা ফাইল করতে করে রাখা উচিত। আপনারা সব একই ফাইলে দিয়ে দেন তো এটা খুব অসুবিধা হয়ে যায়। Judgment in
Lordship, I think, Lordship, for better convenience of your lords, I will just hand over a compilation with index to your court master, Lordship. The matter need not be kept, Lordships.
No, I will have to keep it after going through it.
Lordships.
One day I'll keep it so that if there is some clarification required, because
I had given 2-3 judgments of Allahabad High Court on learned single bench of Honorable Single Bench of Allahabad High Court also. Separately, those were handed separately, Lordship.
Those are there in your notes. In your notes, you have referred to them.
No, but subject to correction is not.
Lordship, Lordship, in the notes, I had given one of them, single iron traders.
Single iron
Lordships. And following single iron, there were other judgments passed by single bench.
Multiplication
Not required.
one is
That is
sufficient
single iron.
because that unnecessary
No, Lordship.
will burden the record.
Lordship, if your Lordship allows these judgments and the judgments which are a part of the writ, for the part which are a part of the writ, I can just give the page numbers or I can attach also if your Lordship says.
Attach it. That will be better.
Then I will
have one.
Yes, I will, sir. Lordship.
Because some I may miss, some I'll.
Lordship, I will.
Yes, Mr. Chakraborty.
Last 1 minute.
This is Shanti Kiran.
Yes, my para 7. Right thereof, find that there is no dispute regarding the selling dealer being registered on the date of, and neither the transaction nor invoices in question has been doubted based on the inquiry into the vessel. But that case has not come. With my understanding that the state of issue control relies about 30 judgments. But I am being told to consider those 30 judgments. So this is my submission.
Very well. I'll keep it on one more day
Lordship.
so that we can organize.
I will prepare that and keep it ready in this week, Lordships.
Heard Mr. Kanodia. Supplementary. 37 is same order. Continuing.
My lord, in item number 34, my contention was that both the show cause notice as well as the order were time barred. But my lord, the notifications by virtue of which they had issued those orders and notice were not challenged. My lord, therefore, I had filed this application seeking addition of, my lord, the grounds as well as the prayers.
Can আছে can ফাইলে আছে
Can 1 of 25.
can তো লিস্টে অ্যাপিয়ার করছে
File.
can আসে না কেন দিদি ফাইলে লিস্টে আসলে can তো ফাইলেও থাকা উচিত না I'm making it not today. Incorporate it in the file. একটু করে দিন আনিয়ে ঢুকিয়ে দিন Yes. চলুন You are appearing 35.
My lord, the advocate on record is not appeared. Not today.
Not today.
36, 35, 36.
35, 36, not today.
My lord, I am appearing for petition. The lordship sleep, with the lordship sleep, my lord, I am filing this supplementary. everything,
There
my
was
lord.
a direction to file. There's been delay on my learned friend side.
Yes,
So
my lord.
a week's time, and by Wednesday will. By Wednesday will file.
Don't-
No one has come.
No, this is the matter, my lord, wherein the proceeding has been initiated against in the name of the deceased person, my lord. So your lordship indicated, my lord.
Therefore, the dead person has also replied to the notice.
Yeah, no,
That is the-
Yes.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Copy thereof has been served upon the learned advocate appearing for the respondent GST authorities. Full stop. Mr. Chakraborty, learned advocate, appearing for the respondent GST authorities, takes time to file report in the form of an affidavit in terms of the order dated November 12, 2025. Full stop. As requested, list this matter on when, how much time do you want, Mr. Chakraborty?
But on a safer side, I'll.
List this matter on January 20.
But now this is out of my syllabus. We fund their order.
Who is appearing for the
They had filed, there was a direction to file a fresh order of appeal order. They had filed, they have served. Can you repeat that?
not today? Next. Not today করে দিন।
Shubhadeep was appealing. There was a direction to file a
Supplementary affidavit. Making it not today.
Oh, that is a scrutiny matter.
Yes, Mr. Bhattacharya. What are your instructions? No, not document itself. You had taken time specifically to take instructions. Please, you have shown the documents. Please don't show me the document again. What are your instructions? Have you taken instructions or not? Because after wasting time, then it becomes difficult. To come to that only, not from the document.
Regarding point, my lord,
Yes.
that fact depends, my lord, the superintendent cannot, my lord,
Show me.
focus notice that is, my lord, the that was the notification dated September 2016.
Where is that notification?
It's a 104. 2016 1049. Can you take number 2I?
2I. Yes.
Except involving etc. and extended period of limitation shall be kept out of the purview of the adjudication by the supervisor.
So show cause notice is without jurisdiction.
Only thing, my lord, I have got a decision, my lord, clubbing of, my lord, years. That decision very high.
That is
No
there, but
contract.
if the notice is without jurisdiction, what will happen?
My lord, I cannot develop what is here. I cannot develop
Clubbing of how many years?
clubbing of 4 years. 4. Sir, my lord,
2 years point of.
my lord, 14,
Clubbing of 2
years.
years.
14, 15 and 15.
This case was
My lord, 14, 15 and my lord 16, 17 years. My lord. Loss is find at page 54, my lord.
So clubbing will come only after
After
jurisdiction.
jurisdiction, my lord.
Jurisdiction point, if at the threshold goes, then the other points
Then
become
nothing
meaningless.
remains, my lord. Nothing remains.
And Mr. Khan had relied on a 2020 notification circular.
There are two notifications. This notification which has been presented now,
Yes.
that only changes the monetary limit. It does not touches upon this restriction. Exclusion part it does not touches upon.
No,
Earlier,
it does. See item 2.1.
two
I-
one is 2.1 is same is as earlier exclusion, only the format has changed.
No. It says cases involving taxability,
Huh.
classification,
Yes, my lord.
valuation,
Huh.
and extended period of
The,
limitation.
the same.
So all of this will be not only
And-
monetary.
No. The change brought in by this notification is only in respect of monetary limit.
Which one?
This later one,
The
1049.
2021.
Huh.
It has been brought down to 1 lakh.
No, it has enhanced, my lord. It has enhanced to 10 lakhs. But that restriction that such classes will not fall within the jurisdiction, that remains as before.
Second line of the I equality. Such cases up to the rupees 10 lakh can also be added to deputy commissioner or assistant commissioner.
So 10 lakh was also not within the purview of superintendent according to
To
2016.
earlier notification, my lord.
Maybe by 2020 it was enhanced.
Enhanced,
Where is
but
that
it does-
2020 notification? Yes.
This is 1049 of 2016, my lord. Enhancement is by notification number 1049 of 2016.
No, in your submission which you made.
That is 2010, I think, my lord. 2010.
Oh, that is the typo then.
Huh.
Paragraph 4, it says September
No, that
21,
was
2020.
notification dated 21st September 2010.
So what was up to rupees 1 lakh?
That has been that has
brought
been
to
enhanced
10
to
lakh,
10.
but even for 10 lakh, superintendent's power.
Restriction remains. That power not to.
No. Here also it says up to 10 lakh will not be by superintendent. It says
Yes.
by deputy commissioner or
That
assistant commissioner.
restriction or exclusion remains there. It does
Even 1 lakh,
excluded.
this has
Out
been done away with.
and when done with, it is out.
Very well. So I am setting aside.
Question, my lord. Setting aside with no liberty.
No, if the jurisdictional officer can do it, he will be able to do it.
There is no limitation has hit long back.
That
Anyway,
that
is okay.
will
Set
be
aside.
decided. That
Okay.
will be decided.
Okay.
Only on the ground of jurisdiction I am going. So,
And
done by by the superintendent. That is a clarification of
Second line.
2.1. Yes. See, such cases means cases relating to taxability, classification, valuation, extended period of limitation up to 10 lakhs shall be adjudicated by the deputy commissioner. You please read again. I will also read again. Hard লিখে দিন কালকে আমি dictation দেব because this type it becomes difficult. That is not in doubt.
Designation has been.
नहीं
কালকে continuing matter হিসেবে দিয়ে দেব। কালকে না করে day after tomorrow করি। Day after tomorrow.
day after tomorrow.
Problem?
No, now doing this case is becoming a problem coming with Mr. Bhattacharya raising so many objections at the last.
That he is entitled to do. But should I keep it next week?
No, fine. Tomorrow. I will be there. Tomorrow.
Day after tomorrow.
No,
Day after
tomorrow.
Day after.
If the bench thinks day after tomorrow, then it is day after tomorrow. If I have choice, then let it be tomorrow.
Yes. Not today for me. Next.
If I wanted to file, us to file a report, it is and so can you keep it on Wednesday with that?
Very well. Mr. Chakraborty, learned advocate appearing for
I appear to the petitioner. Well, on the earlier occasion, the Lordship was pleased to direct to file a affidavit
yes.
to both the parties that how I have calculated the interest. Well,
But I have also not filed a
No, I have
report.
directed you all to share it with each other.
I have
That
shared,
is the order.
they have not shared.
I have received it. National calendar, adjourn it,
I am making it not today. You.
Well, kindly keep it on the record. I
Why
have
unnecessary?
already handed over to him.
This I did not ask for an affidavit to be filed in court. There is no order. I said you exchange it between yourselves so that you can address the court with clarity. That is the order. Why are you filing an affidavit? It was because there was a tussle as regards calculation, which I will not be able to do. You will have to sort out. That was the order exactly. See the order?
Yes,
I remember it.
national calendar. Great to know.
Yes.
I didn't call for an affidavit. Not today. Not today. So online चीजों को चाहिए।
पुराना बेरिए तो मैं इसे आनते हैं ये दुर्घटना इंस्ट्रक्शन
And I am for the petition. Ballot department takes to instruction, Lordship directed to instruction.
Yes, Mr. Chakravarti.
Yes, yes. Next thing,
What is this matter?
My lord, cancellation of registration, my lord.
Cancellation of
Yes,
registration for
not-
what? Non-filing of return.
No,
The ground is not mentioned there.
not in existence. Well, it was
Not
for a long time when it was 6, 8 years when it. And they have said it's a cooperative society, so.
You don't have the instructions as yet.
Yes, yes.
So what to do?
But usual order, but he has to pay all the fees, late fees, penalty,
my
whatever.
lord, the
No, but the show cause notice says something else.
Yes, sir, that is of 2018.
Yes.
But today the situation is when it can.
I am giving him liberty to approach you for revocation.
my lord, revocation time already gone, my lord. Revocation time already.
Outer limit has also gone.
Outer-
180 is the amount.
Because 2018, why have you approached court also so late, 2025? After 7 years?
My lord, the board was in during the COVID time. The board management was not.
COVID has long gone.
My lord, that's why they
When
cannot.
2018 it was done, COVID was not even a word in the dictionary.
That's why they cannot
It came in
approve. My
2022. So
lord, I am agree to pay the demand also.
that
My lord,
doesn't
I
help.
restore my registration. I can continue my business. This is by Samit, my lord.
It is not one of those
And
usual
they
cases
be-
where it has been done because of
They verify
non-filing
that
of
my
returns.
they verify my place of business, my lord, physically. Last occasion after your passing lordship order.
Mr. Chakravarti, then file a report if it can be done, then I'll do it because I will unnecessarily not pass an order after 7 years.
Also, we cannot write it in the this has to be. I'll leave it to your lordship because instruction is as on date, it is in existence. And they have inquired into the Poncha, what PAN card, everything.
They all verify the documents, my lord.
Whatever it may be. After 7 years, you cannot come to court at any time. Whenever you wake up from slumber, you'll come to court after 7 years, 10 years. If your business was not running, that was all the more reason for you to be to be vigilant. You cannot sit tight for 7 years and suddenly come to court and want an order. That can't be done.
My lord, the society in remote area, my lord. Therefore,
Whatever it is, where is the
and during the
explanation? Where is
meantime,
the explanation in
during
the
the meantime, my lord,
Where is your explanation in the writ petition? There has to be something for the court also to act upon. Court is not God that it can do anything.
I am stated in my paragraph 18, my lord.
You say Samiti was formed again in 2024.
Yes, ma'am.
Where is the proof of that? That the Samiti was reconstituted in 2024?
I am, my lord, it is what record on minutes books.
Show something to the court. You cannot do this. Suddenly after 7 years, 8 years, you will come and want it to be reconstructed.
My lord, kindly grant me liberty to file a supplementary affidavit.
Fine.
To
Let us see what happens. As prayed for by Mr. Bera, learned advocate. Mr. Bera, learned advocate, appearing for the petitioner, seeks leave of this court to file a supplementary affidavit.
This is that.
My lord, this is the matter, my lord, where, my lord, section 50, the word may used in section 54, my lord, was in question, my lord. My lord, we had filed, I have not been able to go to court. My lord, this matter has to be done physically, my lord. My lord, only if it can be taken up tomorrow, my lord.
There's one judgment which says this is a flexible.
When do I keep it? Tell me. Suggest a
My
date.
lord, any
other day, because this will require some time.
My lord, from my end, it will not require too much time, my lord. Maximum 10 to 15 minutes, my lord.
Very well. No, but he'll have to reply to it. If he's not available, it won't have any purpose.
16th subject to manage.
As prayed for by the parties, list this matter once again on 16th is a Friday.
Oh,
On January 19th. 19th.
My lord, not on the 19th, my lord.
20th.
My lord, 20th, my lord, 20th.
20th. January 20, 2026. Next.
My lord, item number 48, my lord, I appear for the petitioner, my lord. I beg to appear online. My lord, in this matter, my lord, we have challenged an order passed by the customs authority, the basis of which were certain WhatsApp chats which have not been provided to us. My lord, on this basis, my lord had
Sanyal is
ordered
appearing
have
from
been
online.
read by Mr. Sarkar, my lord.
Mr. Sanyal is appearing, my lord. Will kindly permit Mr. Sanyal to make submissions.
Mr.
Lord,
Dey,
we
your
have taken
instruction.
instruction, my lord. During the course of the investigation, we have taken statements of the persons, various persons. One person, namely Chandrakant Tripathi. The statement of Mr. Chandrakant Tripathi is part of the RUD. If your lordship kindly comes to page 227.
Two two seven.
227. Serial number 4.
Serial number 4.
Copy of the statement of Sri Chandrakant Tripathi. Now, this WhatsApp chat has been revealed while Mr. Chandrakant Tripathi has given his statement under section 108 of the Customs Act. So, accordingly, this WhatsApp chat have been relied upon. And the statement was made a part of the RUD. Therefore, the statement was provided to them. And this WhatsApp chat has been revealed by Mr. Chandrakant Tripathi during the course of his state giving exercise. Under section 108 of the Customs Act.
Yes, but WhatsApp chats and the statement are not the same. WhatsApp chat is something else.
WhatsApp chat has been expressed by Mr. Tripathi during his while he made
He
his
had
statement,
disclosed
when
about
he
the
made his
WhatsApp chats were
yes,
in these statements,
in the statement.
but the content of the WhatsApp chat have not been recorded in these statements.
It has been recorded. If your lordship so directs, I can produce the statement also.
Because if the statement encapsulate whatever is there in the WhatsApp chat, then that can be
Because
one
this
way to
WhatsApp
look at
chat
it.
has been on many occasions, on number of occasions have been referred to in the said statements, and that is the connection.
No,
by
referred to means, say, for Mr. Dev, for example, I can refer that I had WhatsApp to him on such and such date. But what had been WhatsApped, if that is
the
not clear,
contents of the WhatsApp.
yes, the content is not clear, then in that case, that makes no sense. I mean, it will not have any bearing. I will have to be made aware of what the content of the WhatsApp was. It is only then that I will be able to form an opinion about it as to how I am to react to it. I'm supposed to react to it. I'm supposed to give my reply on the basis of the material with which I am confronted. Now, there is certain material which you rely on for the purpose of arriving at a conclusion. WhatsApp chat is one of such materials. Now, if those chats or the content thereof is not part of the statement, then in that case, there may be some problem.
We have to also see the contents of the statements made by Mr. Tripathi while giving his statement under section 108. And that apart from this WhatsApp chat, there are other documents, other evidences, and other materials on record, on the basis of which one of these order has been passed. So these WhatsApp chats are not the sole criteria, the sole material evidences on the based on which this order has
So
been
do you
passed.
mean to say that by supplying the statement of Mr. Tripathi, the requirement of making over the WhatsApp chats has been done away with?
Has been done away with, subject with a rider, my lord. We have not checked up these statement made by Mr. Tripathi. We need to see the statement also.
Let me hear Mr. Sanyal on this.
No, my lord, this has, may I take your lordship's one that will make the clear that this is the, according to me, almost the whole basis of it, page 293 of the
No, the statement of Mr. Tripathi was supplied to you.
The statement annexure was supplied to me, these annexures, not the statement.
No, I'm told, my lord, these entire RDs are always given.
If
Because
the statement
show cause
is given
notice-
to you and the statement contains the
My lord,
contents of the
it doesn't, my lord. Now, this I tell you, lordship, this has twofold of effect. Suppose your lordship's statement contains what the WhatsApp contains. Now, the WhatsApp messages have been produced according to them in evidence. My lord, that has to be authenticated. By whom this was authenticated? My lord, this has to be from the service provider, because my mobile has been seized by them. It has to come from the service provider. WhatsApp ad screenshot provided by one witness cannot take place the authenticated evidence. Even if it is produced in the statement he records, the original that has to be produced with the certificate. Nothing. And kindly, your lordships, the entire mens rea is based on that. Kindly have a look at page 293. Kindly see paragraph 14.2.3 mens rea. The overwhelming and consistent evidence, including direct admission by co-notices, irrefutable CDR data, I don't have, authenticated WhatsApp communications.
It says authenticated.
Who authenticated, my lord? That I do not know. Authenticated by the witness, the same person who says I had the communications. Does it amount to authentication, my lord, under the law? I produce, my lord, screenshot in evidence that this is from my mobile. That means that I am saying this is from my mobile. But who authenticated it? I cannot authenticate it. Authenticated must be from the service provider. So this is an evidence. This is almost capital punishment you are imposing upon me. Everything should be disclosed to me so that I can deal with it.
What is the punishment?
Kindly look at that. That your lordships, page 301.
It's only imposition of penalty.
That's your lordship. It's almost
It's not
capital
a capital
punishment.
punishment.
According to almost penalty.
Civil. Evil civil consequence. Yes, Mr. De.
These were all Nepal bound transits. In the documents, they have
White rice.
have declared those to be white rice. Came out to be bitter nuts.
2 crores.
No, that's
More than
facts.
2 crores.
I'm
And
not on
Lordship
that.
kindly sees also further that apart from
Only on the natural justice aspect, because that will not go into merits. If we find that, yes, I am only on the procedural
Exactly.
propriety. If procedural fairness is there, in writ jurisdiction, I will only test that, not the decision. Decision may be right, wrong. Even if it is wrong, I will not interfere if I find that it is fair. Decision authority is entitled to give a wrong decision. It will be corrected in appeal.
yes,
Writ court, I will not do it.
yes.
If I find that the procedure has been correctly followed, it is fair. Now, if there is some lacuna in the procedure,
I will show to your Lordship what are the evidences apart from the WhatsApp chats upon which the authority concerned has relied upon while coming to the conclusion. For that, Lordship kindly comes to page 292 once.
না তাহলে তুই করছিস আমি তাহলে সেভাবে বলি let my learned friend take a decision, then he will not produce any other documents or anything, whatever appears
If
from
the
the
Lordship
record.
so directs, I can produce further
That's-
documents.
Make up your minds.
no, you produce it to show that yes, WhatsApp chats were communicated, or if you don't want to produce, then you take a stand that WhatsApp communication, even without that, your charge could have stood.
That is another over the statement. In that case, Lordship kindly gives me some time so that we can go through the statement
Tell
of
me
Mr.
when,
Tripathi,
because-
from which will be very vital.
Tell me when.
And if your Lordship so directs, we can produce the record of before your Lordship also.
No, producing before me will not do, because you will have to see whether they have been, because I may be satisfied, but my satisfaction will not inure to your benefit until and unless it can be shown that fairness has been shown to them. So you first satisfy
Yes,
yourself,
yes, definitely.
and if you can take that stand, then we shall proceed further.
Very well.
When should I keep it? Tell me.
ওটা আমার দেরি লাগবে রে
10 days to 2 weeks time.
2 weeks.
10 days. 10 days.
No, at least my lord, they will maintain status quo.
We have not proceeded anything. We have
At
kind
least
of-
record
we have
that,
issued the show cause notice. The order has been passed.
So that's the lawsuits.
What is the
Don't
next
proceed
stage?
further.
What is the next stage? Recovery.
Recovery, for that they will receive a notice.
Very well. If notice is served, then in that
Then I will.
heard Mr. Sanyal, learned senior advocate appearing for the petitioner, and Mr. De, learned advocate appearing for the respondent customs authorities. Full stop. Mr. De, learned advocate appearing for the respondent customs authorities submits that. What was the page, Mr. De?
Lordship 227.
That
May I take your lawsuit liberty?
Yes.
To go to that. Go to my 18.
that RUD4, RUD capital hyphen 4 being এটা inverted comma being copy of the statement of Shri Chandrakant Tripathi dated July 19, 2023 had been served upon the petitioner, and service thereof might have done away with the requirement, might have served upon the respondent, upon the petitioner, full stop. He submits that he needs some time to go through the said statement and take appropriate instructions as regards the writ petitioner's contention of non-furnishing of the WhatsApp communications referred to in the order in original. Full stop. Paragraph. In order to enable Mr. De to take appropriate instructions, comma, list this matter once again on January 20. Mr. De, 20th January.
21st, because the honorable division which has fixed 4 matters.
January 21, 2026.
Grateful to you.
Grateful, grateful, Lord, grateful, Your Lordship.
Hearing on this matter, Your Lordship, this matter is quite similar to my lord, item number 1 in the original side that was heard by my lord yesterday. In this matter as well, Your Lordship, 148 notice has been directly issued by relying on 135A information received. And my lord, here also 133.6 notices were issued to the assessee. Assessee had, in this case, filed detailed replies along with supporting documents. And Your Lordship, the 148 notice has been issued to the assessee saying that it is pursuant to information received under 135A. And my lord, here, my lord, the issues are that the department has tried to flag two transactions on which 133.6 notices were issued. One was, Your Lordship, interest received by the petitioner. But the petitioner replied saying that all the interest received were duly
Here also you have objected to the 148 notice.
But we had in this case filed a response to the 148 notice, wherein, Your Lordship, we asked for the reasons. Because, Your Lordship, we've only been given the 148 notice, Your Lordship. The approval copy, nothing has been given to us, although it mentions an approval. But, Your Lordship, nothing has been provided to us in this case. And, Your Lordship, in our humble submission, Your Lordship, the entire proceedings are invalid because, Your Lordship, the department's contention in the 133.6 proceedings, because, Your Lordship, 135A scheme contemplates proceedings under 133.6. In that, the department's two queries were interest received and interest from income tax refund. I filed a detailed reply. And even in response to the 148 notice, Your Lordship, I had asked specifically for the reasons and for the documents, and I said that the entire proceedings are invalid as there is no information against me whatsoever. I had filed that response in June itself, Your Lordship. Your Lordship, there's been no response from the department, but nonetheless, Your Lordship, the proceedings are invalid because, Your Lordship,
Yes, Mr. Dutt.
He has challenged the violations of section 148.
Virus point will come later. We may not require to go into that, but if a notice under 148 is issued without following the procedure of 148A as is permissible under law, then if the assessee writes to you seeking the disclosure of reasons or makes objection to the 142 notice, raises objection to the 148 notice, then in that case, why should the GK and drive shaft principle not be applied? GK and drive shaft principles has to be applied.
Because the reasons has to be provided. So reasons for it 156.
But yesterday,
It's 3. Original side will be taken up. I'll take it up tomorrow.
my lord, and my lord's order I'll be relying on, which was passed yesterday, and that probably will be uploaded, so I'll also be relying on that.
Not today.
Can you keep it day after? Yeah, tomorrow I will be starting the appeal.
My I'm in some personal medical difficulty, and because of that, my
Very well. Heard Mr. Jhunjhunwala. Be applied because under the earlier regime also it boils down to the same thing.
But here, my humble submission would be that the 140, the 133.6 notices and the inquiry made, that is the entire basis of the 148 notice, because it talks about 135A information. And in my humble submission, there is no information at all, because the 133.6 investigation of the points put across.
136 he was provided with the reasons. But
If he object to it,
148 when he has objected to it, I have to provide.
GK and Drive Chef says that if you object to 148, then the objection must be disposed of before proceeding further. That has to be done.
I'm grateful, Your Lordship.
Original site of also.
Madam, may I, my lord, kindly to mention a matter, my lord, serial number 44, my lord. The interim order is expiring on 31st of January.
44.
Yes.
44 का ये the extension of interim order. Yes.
With my lord's permission, may I mention, my lord, it's for upgradation. My lord's item is for ripe for hearing. The reason for mentioning is, my lord, since 2020, our refund for the amounting to around 64 crore is stuck with the department because they have refused to implement the Honorable Sistat's order, Honorable ITAX order, my lords. Therefore, my lords, I'm praying, pleadings are complete in the matter, my lords. It's ripe for hearing. It may be given some indulgence.
Appearing in the list, no.
Appearing, my lords, 76 number, item 76.
Item 76. से फाइल देखिए।
Mention item numbers 32 to 34. But actually, this matter was previously taken up by my lords on before the vacation. This entails the point that whether pursuant to the tribunal's order, the department was supposed to pass the give effect order within the time limit provided under 153. My lord had indicated that this matter may be fixed for hearing today, but a little towards the top of the list, my lord. If it may be upgraded tomorrow, because the similar matters are also there on the appellate side, your lordship.
Very well. We'll see and upgrade it tomorrow. I'll get the
32 to
33, 34.
I'm grateful, your lordship.
32 to 34 will I'm for the department. Just may I have the copy of
But we'd given
a copy of the petition.
But I have previously Mr. Sharma had appeared, he had a copy, he said that he will be taking instructions. I could a copy has been served.
I could not get the
Then please wait because
My lord.
without instructions there's no use.
My lord.
After you come back, you mention.
My lord. I'll also provide another copy, my lord. Okay.
Yes.
line for the
Wait, Lakshman. This is also a case where the 148 notice has been directly issued without referring to following the procedure under 148A. But there was a search against an asset reconstruction company. Well, I'll explain the role. So because of that search, flowing from that search, this 148 notice has been issued. So there are certain provisions, if my lord is pleased to have note, section 152, subsection 3. Yes, 152, subsection 3.
152.3.
Yes, ma'am. Where a search has been initiated under section 132, requisition
Yes,
is
147 to 151 will apply.
yes, the old ones. And in this case, the search against that asset reconstruction company was in December 2021. And kindly now have the
old section 148, explanation 2. Lord, explanation to clause IV, where the assessing officer is satisfied with the prior approval of the principal commissioner or commissioner that any books of account or documents seized or requisitioned under section 132 or section 132A in case of any other person on or after the first day of April 2021 pertains or pertain to or any information contained then relate to the assessee. Then
This
what
is
the-
old section 148.
Yes, not in the footnote.
I don't have.
Not in the footnote. No, I just.
Yes, I've got it. Yes.
Lot. But because not that the September 2024, the amendments took place, so not it is in the footnote. So not the old section 148.
Yes, got it.
Lordship.
Seen it.
For the purpose of this section, where the assessing clause 4, the assessing officer is satisfied with the prior approval of the principal commissioner or commissioner that any books of account or documents seized or requisitioned under section 132 or section 132A in case of any other person on or after the first day of April 2021 pertains or pertain to or any information contained therein relate to the assessee. The assessing officer shall be deemed to have information which suggests that the income chargeable to tax has escaped assessment in the case of the assessee, whether search is initiated or books of account, other documents or any assets are requisitioned or surveys conducted in the case of the assessee, or money, bullion, jewelry or other valuable article or thing or books of account or documents are seized or requisitioned in case of any other person. So there's that deemed satisfaction, like that the present provision. And in this case, then 148A, because it is the 148A procedure is dispensed with in a situation like this, because the information that my lord will find.
First proviso C.
Lordship. Therefore, in this case also, I'll show the factual background. In this one, the petitioner is the manufacturer of purified terephthalic acid. It's a part of that Haldia Petrochemicals, the Chatterjee Group. They are in this business. So they're a manufacturer of this item. A company called Garden Silk Mills Limited was one of the customers of this particular petitioner, the company. So that company there was a corporate insolvency proceedings in its case, and in those proceedings, there was the lenders decided to hold an open competitive bidding or auction for selling the entire debt of that particular debtor on cash basis. So there's a company called Invent Assets Securitization and Reconstruction Private Limited, the asset reconstruction company. So that company participated in that bid and was a successful bidder. So the bid was made for 670 crore. Now before this particular bid was made, they had obtained from me an amount of rupees 10 crore initially. That was an advance agreement. Interest at the rate of 5% was per annum was payable to me, and they said that they wanted this money to make a bid for that in that process. So thereafter, there was another agreement, a term loan agreement. Soon thereafter, where I agreed to give, they could draw up to 700 crores from me. The interest rate, which included this 10 crore already given, and 6.5% per annum was the interest. So on this basis, the money was to be given. There are documents. Those documents have been disclosed to the department. Now this So because they were the successful bidder, the entire debt was assigned to them. So they became they had the entire thing with them. The banks and all went out of the picture. After that, this company, there was the NCL team admitted the Section 7 application in June 2020. This debt assignment was in February 2020, and in June 2020 the resolution professional was appointed. And this petitioner also made a bid. A resolution plan was submitted. There was another contender. So two entities have submitted a resolution plan, and my plan was accepted. The NCL team approved my plan on 1st January 2021. So there was a special purpose vehicle, a wholly owned subsidiary of mine, which took over the entire that company. What happened was that first shares were issued to that special purpose vehicle, and the scheme itself provides that. And then there was a merger of that company with that garden silk with the special purpose vehicle. So and that the debt was before that merger, the debt was assigned to, because the scheme provided, the resolution plan provided that I would pay 717. I, in the sense that the special purpose vehicle would pay 717.50 crore to the asset reconstruction company. They had bought for 670. That was their bid. But I was to pay 717.50 crore to the asset reconstruction company. There were certain other payments also. So this was how the transaction would happen, the takeover of that particular garden silk. Now, in December 2021, there was this search against the asset reconstruction company. The several things were found. There were certain statements were recorded of the chief executive officer of the asset reconstruction company. There are certain people involved who were called coordinators. Their parallel books were found. There was seized material at the asset reconstruction company by way of billing sheets. And there were statements of the employees of the coordinators and the coordinators themselves. So what they found from all this was that there was a particular modus operandi being followed, where the persons who had who owned that company, the borrower group or interested group, they call them, they were in effect they were the borrowers themselves, where that non-performing asset was there in that company. So they were the borrower group interested in that company or owning that company. They used this process to acquire that debt at a reduced value, because in the resolution plan the value gets, the haircut happens. So they would not acquire the debt at a lower value, and that way in that way the creditors receive that lesser amount. Whatever. Now, whether that part is correct or not, that's a separate matter. But what was found was that in the process, the borrower group was or interested group were providing cash, and that cash was being turned around and by accommodation entry, and the money reached the hands of the asset reconstruction company through various routes. I will place that the satisfaction note. So that was the what was found. Now, I received summons under section 131(1)(a), and in February 2022 from the investigation department, making various queries. I will place that. I gave answers. The queries were whether I was related with Garden Silk or I was related with the asset reconstruction company, whether I had paid any management fee to the asset reconstruction company, because my lord, what was found in that modus operandi was that the asset reconstruction company, my lord, paid interest.
Where is the notice, Mr. Chetan?
Lordship, my lord, the 148 notice?
Yes.
My lord, kindly have, my lord, volume 3, my lord, at page 313. my lord.
313.
Yes, ma'am.
You have objected to this.
Yes, my lord. I have, my lord, with this, my lord, there are 2 years before my lord. So this is assessment year 2021. The next is 21-22. Not the satisfaction note was not sent with this notice. In the other year, it came with the notice. So not I had the advantage of the satisfaction note because not 667.45 crore was given in this year, and 3 crore 40 in the next year. So not the content had to be the similar on. I asked for the satisfaction note, but I also not prepared the objections on the same lines for both the years, and I submitted that. So my first objection was on 20th June, and then I supplemented that because I had to file my return under protest. I recorded that protest, and I supplemented that on 30th June, and then they were issuing notices under 143.2 and 142.1. I again objected to that as well. So the objections are as such in these 4 letters which have been filed.
This has not been considered.
No, they have not. And the interesting part is that not only did I get that 131(1)A summons, there was also not a 133(6) proceedings. And in that also I was asked, I disclosed all the loan agreements. And I said that look, I'm unrelated to. I was mentioning about the management fees. What was happening was in that modus operandi which was being followed. So the asset reconstruction company borrowed the money on interest, so that it was out of pocket by the amount of interest. So these people compensated them by that some other company of that asset reconstruction group raising bills for professional fees. So that those professional fees were paid to fund that particular payment of interest. So that was the modus there. So I was asked whether I had paid any professional any charges, professional fees. I answered that no, I did not. I'm unrelated to Invent. I'm unrelated to the Garden Silk. And
what is the reason for them to relate you to Invent?
They have mentioned about these statements, mentioned about the documents. I am nowhere in that. But they have assumed that I am a group, that Garden Silk, I am a group concern of Garden Silk. Now, there's no basis for that. Not Garden Silk is totally unconnected. So I took that stand that I'm unrelated. Now, they do not deal with that. The satisfaction note shows no consideration of that. So they describe that process. And they say.
And where have you said that you have no connection with Garden?
Yes, kindly kindly have volume 3.
Volume 3.
Yes, I'm sorry, kindly have volume 2 first. Volume 2.
Volume 2.
Page 209 is the.
(131)
Yes, no, this is by the investigation wing, and kindly see the queries at page 210. And this is all relating to this the asset reconstruction company. The query number 7 asking me to explain the association with Invent, and the answer is at page 211. There are 2 answers given. Page 211 is one. My lord will find out that I've given the particulars of the amount paid. But serial number 3 loan agreement I have given. Then what serial number 4, who was I in touch with in the asset reconstruction company? Then what 5, provide evidence of the source of funds. So this is important because the foundation is not that the source of funds is an issue. Provide evidence of the source of funds for transferring to Invent, along with supporting documents and markings in bank statement. I provided that loan to Invent assets had been funded from own resources. Bank statements were enclosed, but I pointed out that I had broken a fixed deposit of rupees 500 crore in order to provide this particular loan. And then what the query says, kindly provide details whether interest on loan advanced to asset has been received with markings in bank statements. So the interest receipt was indicated. Then what in page 213, explain your association. As can be seen from response to serial number 1 and 3 above, assessee gave the aforesaid loan to Invent on a principal to principal basis and on arm's length basis, which was utilized in terms of specific purposes set out in the advance agreement stroke loan agreement. And then what I described the process which happened before the NCLT, and then what the last paragraph on that page. Post acquisition of GSML, the assessee, in line with the objectives of IBC, has put in substantial efforts to turn around and revive the business of GSML and has integrated GSML's operations with the company, which is forward integration for the assessee's business. The entire transaction has been done on arm's length basis between independent parties. Assessee is not related to the erstwhile promoters of GSML through the mechanism of transparent public bidding system as prescribed under the law. Our arrangement with Invent Assets has been set out in the advance agreement, loan agreement, as well as paras referred above, and we have not issued any comfort letter mandate to Invent Assets or any of its sister concerns. So this was, and then there was another reply which is 15th March 2022. But kindly have this 9th March had several annexures, so it has gone into the other volume, volume 3, page 302. So this 15th March 2022. It's again to the Deputy Director. Additional details regarding source of funds that were lent to Invent. Then we again have the details are there, and then in relation to loan agreement, was there any other agreement, communication, direction that the funds were to be used by Invent Assets only for acquisition of Garden Silk? But the answer was there's no that there are only these agreements which we have furnished, and that there is no other agreement. And then was any management fee paid to Invent? Whether any tax deducted source is deducted? The assessee has neither paid any management fee to Invent.
All of this does not appear to have been considered.
Not at all. And then this was from the investigation wing. But thereafter, kindly take note page
305.
Yes, no, 305 is the notice under 130.
133.6.
Yes, no, and this is not from the Bombay officer. Not the officer, my assessing officer is here, but I get this from the Bombay officer. And I answer this, and here the kindly see the answer at page 310. Query number 4. Whether the company, including its employee, promoter, shareholder, has any relation with director, shareholder, promoter, employee of Invent Group. Now, this is the asset reconstruction company. Manish Lalwani, Dipen Mehta, these are the so-called coordinators, or his associates from the date of incorporation of the company till date. The company, including its employee, promoter, shareholder, has no relation with director, shareholder, promoter, employee of Invent Group, Manish Lalwani, Dipen Mehta, from the date of its inception till date. Then kindly see at page 312, serial number 14. Whether the assessee or any of its sister concerns had any connection with the promoter, director, shareholders of the NPA. NPA, that is at Garden Silk, and the details of such transaction thereof, if any. The company or its sister concerns did not have any connection with the promoter, director, shareholders of NPA until its acquisition.
And what is the reason for reopening? That
Yes, not I will not kindly take that reasons which are disclosed not on request, not at page 323. Now, I must point out there are two places, not kindly see at page 322 bottom. Not, there is a not that in this and this is the copy as I received. My lord will find that something is cut off at the bottom. Not that last line at page 323. Not in the
yes.
so not this is as I received it. And not, there's one more place I must point out not where the same thing has happened. Not, that is at page not 338.
This is all reasons.
Yes, but I will not summarize it for my lord. But kindly see page 338. I just wanted to point this out before my lord went through this because not the other year is also there. Not based on what is there in the other year, not, I have not put my own words, so to say. But as it please, my lord, I can place this, and for those portions, my lord, I can show from that other reasons. Do
No,
not,
I will because we are at the interim stage.
Lordship.
Yesterday, I thought we'll be hearing, and we heard it, and ultimately, since yes, Mr. Bhomik, why should the objections not be considered before issuing the before proceeding further after issuance of the 148 notice?
So, my submission, my lord, the department is bound to dispose the petitioner's objection. I have no quarrel about it in view of the judgment of the Supreme Court. So, my lord, whether they dispose or not, my lord, also kindly give me short points of agreement, my lord. And if you more
then the on the similar lines, not as yesterday, my lord was pleased to direct, because if they want to use an affidavit, not the
Very good.
because not in the reasons, not they are describing the modus operandi, but not they're not connecting me with. Right, if my lord had asked me that question, but quickly, if I may just show, not in paragraph, look 5.5. It is at page 331. And then I'll take my note to the other paragraph. In the case of BG is not borrower group, interested group, namely Garden Silk, has routed funds to inmates. So the Garden Silk has routed funds to the asset reconstruction company through network of connected entities or through coordinators, and ultimately routed its funds through MCP, I'm not the petitioner before my lord, for acquiring NPA. In other words, the funds utilized for acquiring the NPA of Garden Silk Mills belongs to borrower group and interested group. One fact note is that for both these years, I was assessed under section 143(3). And my in my accounts for those years, these loans are disclosed. There are notes in the accounts where specifically this loan given to this invent note has been disclosed, because otherwise in the balance sheet the consolidated figures appear, but there are specific mention of this loan. And in the next year, upon acquisition of the Garden Silk note, that fact is also mentioned. So in the 143(3) assessment, now what else is said, kindly take note at page 338. 338 and 339.
Yes.
338, the details of loan given by the lender assessee to the invent group is as under. Then they mention that 667.45 crore in the year before, my lord, and 3.40 crore is in the next year. And then in some of the cases, kindly take the last 5 lines of that paragraph. Borrower and interested group have been actively involved in routing of its funds to acquire their own NPAs. In some of the cases, the source of unaccounted loan amount has been identified in the hands of the borrower or interested group, and nexus between NPAs and fund providers have also been established. Then, in view of the discussion in foregoing paragraphs, it is apparent that MCPI Limited, I'll read not from what is there in the other reason. MCPI Limited utilized funds for acquiring the NPA of group concern Garden Silk Mills Private Limited to the tune of rupees 67.45 crore during the financial year 2019-20 relevant to assessment year 2021, source of which remains unexplained in the hands of MCPI. On the basis of above search conducted by Income Tax Department, information suggests that NPA acquisition by the assessee company to the tune of 667.45 crore represented in the form of an entry or entries in the books of account of the assessee has escaped assessment in the case of the assessee for the assessment year 2021. Then what they refer to explanation to section 148, then note 9. Accordingly, in the instant case, a recording of satisfaction that the information contained that MCPI utilized funds for the acquiring of NPA of group concern Garden Silk Mills to the tune of 667.45 crore was submitted before the land PCIT. In this regard, land PCIT has approved the satisfaction recorded by the assessing officer. In view of the above facts of the case, it is inferred that the assessing officer is deemed to have information which suggests that income chargeable to tax of 667.45 has escaped assessment for the assessment year 2021 in terms of explanation 2 IV to section 148. So this is not, but it is purely an assumption based on the modus note which is described in those paragraphs that the borrower or interested groups have funded this particular acquisition. But there is absolutely, because if there was not, and when I was specifically saying so, then they would have brought it out in the the different materials which are referred to as I submitted statements, parallel books of account, the document seized. Then they would have pinned me, totally pinned me, nailed me that this is there's absolutely nothing. Somebody may have done something, but I am not party to it in any way.
This writ petition
Item number 3. For applications under item number 3.
On the last petition, we will file our written notes.
Order sheet take both पूरे किया हुआ है। So written notes are being filed only in 3. Nothing is being filed in 4 and 5.
Rest of the matters also I'm filing today, my lord.
But we have only filed in respect of 3, my lord.
3.
Yes, yes. Still, 4 and 5 are more or less similar, my lord. In one of the matters, my lord, penalty proceeding has not been initiated. In other matters, not penalty.
No, similar in the sense in all of them.
Point of law same.
There is no difference in facts.
Little bit of difference is there.
What is the difference?
Like the next matter, my lord. Actually, we could not file reply because the petitioner was sick. He was not coming to office, so he did not file reply. But case made out by the revenue is.
So your reply was not there at all.
Not
so 148 A3 or AD, whatever it may be.
It was ex parte.
It is ex parte in both the other matters.
Both there.
In 3 there is reply, 4, 5 no reply.
No reply.
And in the last matter, my lord, there is some somersault he is making. Firstly, he is saying SSE has taken loan.
Very well. So I'll go matter by matter. So item 1, so far as item 1 is considered, you both of you have filed your written notes.
Yes.
That a record Koreni?
Lord, some submissions I would like to make as
In
far
item
as
1.
In 601, my lord. My lord, my learned friend has raised a preliminary objection that there is alternative remedy. So this writ does not lie. On that, in my submissions, my lord, at para 10, I have referred to 3 High Court decision, 1 Supreme Court decision, Red Chili, and then division bench decision, Ashiana Housing, and third is Sikkim High Court decision in Jaidas. My lord, Red Chili is in respect of the changed law of reopening, and their lordships are holding that where jurisdictional issue is raised, the writ will lie. And another decision is, I have annexed the decisions also. At page 9 is Asiana Housing by the division bench. The same view has been taken here also at para 3. And the third decision, I am referring to Sikkim High Court decision, wherein, my lord, Ansul Jain has been considered, which my learned friend has relied upon, authored by Justice M.R. Shah, Ansul Jain. And this at para, my lord, page 14, top para, the submissions have been recorded. At page 14, my lord, submissions of the council has been recorded, and why Red Chili will apply and not Ansul Jain. The basic that has been recorded, and the court has accepted. That alternative availability of alternative remedy is no bar to writ petition. And I don't want to repeat, my lord. My only on the last occasion, my submission was that my learned friend has not rebutted what I had submitted. He was making altogether a different plea, but specific pinpointed submissions have not been rebutted, that there is no material on record that I have taken cash loan. If a company or XYZ is taking cash loan, what they are saying
is that somebody else is taking, some company is taking, some neighbor is taking. So every liability will come upon me. That is not as per law. So that has not been rebutted.
Milord, to that my submission is, Milord, that Simaya, Simaya is a company, Milord.
Mr. Agarwal's submission is that
Yes.
if it is a company and it is a separate entity,
Yes.
You should go against the company.
Yes.
You have to go against the company, assess the company.
Yes.
Assess the company's income. After assessment of the company's income, also if you find
Yes.
that something remains to be paid
Yes.
by the company which the company has not paid,
Yes.
it is only then you can revert to him applying section 179, which you have sought to refer.
yes.
That is
Not
only for
before that.
recovery of tax.
Yes. This,
But not
first
for
the
me.
recovery the amount has to be crystallized against the company or
Yes.
against the entity.
Okay.
If it remains unrecovered,
Yes.
it is only then. So first hand laying of the hand first upon the person who is behind the curtain is not permissible, is what Mr. Agarwal. What is your response to that?
Milord, to my response, Milord, Lord Roshi will kindly have a look at paragraph 19 of our note. Milord.
Paragraph
So that,
19.
Lord, I have cited the judgment of Vodafone, Milord, where Lord, he has to corporate veil has to be lifted. No? Entire amount Kasera is directly giving to Samaya. Who is Samaya? Ultimately, the directors are getting the money. He is the main person. That I have stated in paragraph 19, Milord, of my note. And I've cited the judgment of Vodafone to that effect. Do you have a copy?
Vodafone copy has not been given to.
Copy has not been given. It's a long judgment. I have cited. The Vodafone copy has not been given. Milord, Lordship has emailed.
No, it's okay. I'll take it.
Milord, ultimate beneficiary is not the directors. Milord, what the company will do is directly Kasera is sending. It's not directly. Milord, it is from direct amount. It's not that from by other person is taking from directly. The Kasera amount is going to Simaya. So ultimate. Anil Kumar Kasera, in my paragraph 10 will have stated. Page 49 shows that Anil Kumar Kasera is the director of Hatigor Solutions, which is
Page 49 of
page 49 of the petition, Milord. Great petition. First one, yes. You know.
This is about Kasera.
Yes.
How are you embroiling the petitioner?
But in paragraph 10, I've stated, Milord, that directly Anil Kumar Kasera is sending the loan to the company. So, Milord, company is who is the beneficiary? The director is the beneficiary. The company is not in any way. Milord, Lordship will kindly have a look at page 107, 11, 107. Lordship will kindly have a look at page 107. Yes. Yes. Lordship will kindly see, Milord, page 107. Lordship will find, Milord, serial number 201. Anil Kumar Kasera is sending it the loan to Simaya. Same in 111. So ultimately, Milord, who is the Mayank Agarwal is taking the loan? The amount is
not even Mayank Agarwal's name is mentioned.
But he is the director of the company. It is not that, Milord, that somebody else is directly from the Kasera group. Anil Kumar Kasera is giving the loan to Simaya, where Mr. Mayank Agarwal is MD. The loan entire amount is being used by Mr. Mayank Agarwal.
Even that finding is nowhere there. Mayank
that
Agarwal
is
is using that. If the facade is to be broken, that finding should be there. That Mayank Agarwal, that is far-fetched argument. But for
name is there.
Giving a leeway to my learned friend, even that finding my learned friend is unable to show that Mayank Agarwal is appropriating the money for his personal use.
Lordship
not even averment.
Yes. Lordship will kindly come to page 185. Order, page 185. The SSC is not a mere director in name. He is the managing director and the principal decision maker in both the Simaya Fashion and Mrs. Shailaja Housing. The companies are closely held and their financial dealings are orchestrated and controlled solely by the SSC and his immediate family members. Therefore, it is not only the illegally possible but also factually justified to examine the income escaping assessment in the hands of the SSC, who is the beneficial owner of and controller of such transaction. What more can be given?
Family member means everybody will be assessed under me.
No,
Where is
no.
what you are
He
saying?
is being assessed.
That also you are saying that my
Because
family
it
members
is
are
an
also
undisputed
controlling
fact
the
that
company.
he is the principal. He is controlling over both the companies. Yes. For that matter, this surroundings are
Vodafone next para page that Vodafone judgment has been cited for the proposition that substance over form will apply. But that case also, my learned friend is unable to make out. On the basis of seized documents, they are saying that it is a group of people has taken, everybody is clubbed
Very well.
under me.
Very well. लिखे नहीं. Written note of arguments filed by Mr. Agarwal appearing on behalf of the petitioner is taken on record. Full stop. Heard. Mr. Agarwal, learned advocate appearing for the petitioner, and Mr. Dudhoria, learned advocate appearing for the respondent revenue authorities. I am keeping it on one more day. On that day, I will conclude it.
My lord.
Let me go through the papers once.
My lord.
List this matter once again on January 19th, 2026. 19th.
My lord, grateful. Well, in other two cases, my lord, written notes, my lord, shall we file also? Because
yes, definitely. If you want, you can file.
You same, keeping it on 19th? Or?
Yes.
Yes. Will you file out?
Same order.
No, separate order may first.
One small.
Item 4A लिखे दिन. Same order. Mr. Dudhoria. देखिए read copy page 22.
Page 22, yes.
You know, how they are framing the orders and notices without applying their mind, just to somehow bring the SSC's case under the clutches. Well, page 22, last line, loan taken in lieu of accommodation entry. Because they are fully aware, my lord, this shows that the department is fully aware cash loan out of books cannot partake the character of income. So now how to bring the SSC within the ambit? First time I have heard this terminology, loan taken in lieu of, I can understand accommodation entry taken in lieu of cash. Now this is the first time ever somebody is hearing loan taken in lieu of accommodation entry. My learned friends should explain what is the meaning of this terminology. Loan, when a sum, because without accommodation entry, you cannot bring me into the clutches of the law. So somehow invent, use a device.
But it is an admitted loan has been taken.
Very well. Cool.
Number 5.
5 of that matter.
Same order as 4.
Yes.
Number 6.
Mr. Banerjee is there. He's there.
On the last occasion, my lord, we were discussing about the section, Article 45 rather, not section. And the West Bengal amendment, the direction should be given to give effect of the partition.
What is an instrument of partition?
Yes,
Section 215 of the Indian
215
Standard.
read with Article 45, and we are discussing about the 215 and the West Bengal amendment. বইটা বই দেবেন?
Lordship will kindly take up point.
Indian stamp pack I have.
Lordship will kindly take up.
এটা বারবার ঘুরে যাচ্ছে কেন? না ইন্ডিয়ান স্ট্যাম্প প্যাক তো আছে ওয়েস্ট বেঙ্গল ছিল না দেখি
West Bengal amendment.
ওয়েস্ট বেঙ্গল একটা আনিয়ে রেখে দরকার করতে পারে এই মামলাই তো দরকার করবে ইয়েস
Yes, that West Bengal amendment, section 2, subsection 15. A direction must be given to give effect of this partition. And in the final.
Section 15, yes.
Yes, and the West Bengal amendment we were discussing, my lord, in clause 15 of section 2, for the words beginning with and includes and ending with directing a partition, the following words shall be substituted and includes a final order for effecting a partition passed by any revenue authority or any civil court. So if a direction must be given in the final order, so to give effect of the partition, and that is absent over here. And for this reason particularly, since there is no partition and partition is not possible as the subject matter of the property, my lord, I mean the suit, my lord, is too old, and the structural engineer have opined that the partition is not possible and partition cannot be given effect to. For that matter,
Your
the
Lordship referred to a judgment of Justice Ravindran on partition on the last day. I have got that judgment. You can place it.
Is it relevant to this?
In my humble submission, yes, my lord, because partition is preliminary decree. What is preliminary decree? What is final decree?
I found it very illustrative
Very just.
because it removes several doubts.
Something further is to be adjudicated, then it is a preliminary decree.
Otherwise,
If
it's
it
final.
is decided, it's fine. I'll be placing this judgment.
it is slight issue. Paragraph কিছু বলছে? Nine SCC.
Yes, Shubkaran Bhuvi.
Paragraph note 5 to 10 are relevant. Then 12, 17, 18.2 and 31.
Yes, yes.
I have 5.
Just a minute. I'll just note this equation because
This case, my lord,
Everything has been stated. I have কত
yes.
just reminding the facts of this case, one lordship. Preliminary decree was passed. Then commissioner was appointed. Commissioner gave a report that between the plaintiff and the defendant, property cannot be partitioned.
Then there was a sale of certain share of the plaintiff. Then there was reconstitution of share. Then the parties they filed a commissioner then filed a report by giving a map of respective portion, which was accepted by the court. No further direction was given that you do partition it. But not that was, in my humble submission, that is the final decree. Whether it's read as a final decree or not, in substance it is a final decree because rights are finally decided. Now the question which arose is that 215 says effecting an order of partition. So whether that there has to be a direction for partition or the final decree as per CPC, because CPC says final adjudication of all rights would be the final decree. So on that note, judgment is not very illustrative. I'll just say this note, then I'll come back to the factor. Paragraph 5. Partition is a redistribution or adjustment of the existing rights among owners, co-partners, resulting in a division of lands or other properties jointly held by them into different lots or portions and delivery thereof to the respective allotment. The effect of such a division is that the joint ownership is terminated and the respective share based in them shall be severed. Partition of a property can be only among those.
So this was what I was indicating at on that day, that it is not creation of a new right. It only causes severance of right. Severance of right. So it was in that context that I said that it is only when there is a creation of a new right that exigibility of stamp duty.
Incident of stamping is subject to correction by section 3 of the Stamp Act is the incident of taxing. It says stamping. It says that if any instrument is executed in the state of West Bengal, which is mentioned in the schedule, it has to be, the stamp has to be assessed at the rate provided in the right hand column. So if the document not finds place in the schedule 1 capital A, then it is not, the stamp has to be, unless not the entry is challenged by somebody. Section 3 does not say that there has to be creation of right. It says any document executed in
because incidence of stamp is on the instrument and not on the transaction.
Because registration is separate.
Registration is separate.
It might
Yes.
be registered, but even then execution means it has to be stamped.
Yes, because it goes by the instrument. The substance of the instrument is important, whatever may be the transaction.
In the state of West Bengal. Otherwise,
no, it will be everywhere that way. Because so far as registration is concerned, yes, it is transaction based. But exigence of stamp duty is instrument based.
it may be a property outside West Bengal also, but the parties are executing the document in West Bengal, then it becomes eligible to stamp. So, not creation of right, it might not be a case of creation of new right.
For that, registration may not be required.
Registration may not.
But stamp duty, it has.
Draws the stamp. Partition of 6, paragraph 6. Partition of a property can be only among having a share or interest. A person who does not have a share, these are
skipping.
Paragraph 7. The suit for partition or separation of a share prayer is not only for declaration of the plaintiff's share in the suit property, but also division of his share by metes and bounds. This involves 3 issues: whether the person seeking division as a share or interest in suit property, whether he is entitled to the relief of division and separate possession, and how and in what manner the property should be divided by metes.
Mr. Banerjee, para 18.
Para 18. That is the summation.
Yes.
Before that, not only not the what will kindly consider to para 9. Final decree was not fine. Yes, para 10. Para 10 what should the terms preliminary decree and final decree used in the state rule are defined in explanation to section 2.2 of the code and read thus: a decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit.
That's CPC decision.
That's CPC. So, final decree, I say this is a final decree because it has been finally disposed. It has been disposed of. There might not be specific direction for effecting partition, but it is a final decree. Then we learn
18.3.
18.3. So 18.2, I want to point out one portion. 18.2, the last part will also be fine. We learn the function of making a partition. Making a partition of separation according to the rights declared by the preliminary decree in regard to non-agricultural immovable property and movable goods. Entrusted to a commissioner as the involved inspection of the property, examination of various alternatives, when the commissioner gives the report as to the manner of division, the proposal contained in the report are considered by the court. After hearing objections to the report, if any, court passes the final decree, wherever the relief sought in the suit is granted by separating the property from lease and bounds. It is also possible that if the property is incapable of proper division, the court may direct sale thereof, and distribution of the proceeds as per share deed. And also it is a part final. Might not be that court directs to party.
But in such case, stamp duty will not be, stamp duty,
Sale, then they would not. They would
then
not.
If it is a
stamp duty
stay,
will be on the conveyance then.
Then in that case, state in the present three, as the declaration of right of
No,
share-
there is no doubt that it is a final decree, but every final decree will not be exigible to stamp.
yes,
If it is a
not an
final decree
instrument.
which directs partition, it is only then that it will be exigible
Final
to stamp duty is the argument.
that is the argument. Not
For
definitely-
stamping, my lord, it has to be an instrument.
No, it is definitely an instrument.
And our,
Decree is an instrument, yes.
Instrument.
But whether it is an instrument which should be stamped or not is to
That
be
the
seen.
question. Now, entry 45 says instrument of partition as defined in section 250. Now, instrument of partition means any instrument whereby co-owners of any property divide or agree to divide such property in severalty, and includes also a final order for effecting a partition passed by any revenue authority or civil court and an award by arbitrator. These are
Directing a partition.
directing a partition. Then West Bengal amendment is a final order for effecting a partition passed by revenue authority or civil. Now, in this case, my lord, what happened? The commissioner initially there was not question of impartability. Then a portion was transferred. Then final decree, the peak plan was prepared. That plan was made a part of the commissioner's fee. Now the parties now are not having respective ownership and possession over the portions allocated in the decree. So the moment court makes that a part of the final decree, the parties are directed to not have that respective possession as per the final decree. So now there's nothing more remains. Preliminary decree, parties have to demarcate amongst themselves. If it is the final decree, then as per the allocation done, parties have to take the respective possession. If not done, then execution starts. So we are post the stage of final preliminary decree, final decree, then the stage of execution starts. Now, if your lordship sees the plan that they have annexed
supplementary.
to supplementary affidavit, my lord. Here not they are showing separate possession. A and B 25% share and B 75% share with specific covered area marked in different colors. So respective positions have portions have been allocated for the respective parties. So that means that the parties are to separate and not enjoy separately those portions allocated. Now, if it is not done, the next is execution. We're not on that stage. So in my humble submission, the moment court accepts this plan and makes it a part of the decree, court is in effect directing the parties to possess as per this plan. So it's a separate possession in that sense. Because not the last part is, although the initial part says impartible, then last part is as the plaintiffs have relinquished their share over the property, the executing conveyance in favor of defendant number 3. Defendant number 3 is entitled to get his share of 12.5% along with the share of the plaintiffs. Then defendant number 3 has submitted the copy of the conveyance deed. Parties have accepted the plan for proposed partition submitted by partition count. Kindly mark these portions. Parties have accepted. So mutually they have agreed to a proposed partition. These are page 12 of the subject. The final decree.
Petitioner.
Page 12, paragraph 10. Defendant number 3 had submitted the copy of the conveyance. Paragraph 10 had submitted the copy of the conveyance deed dated 5th August 2023. Parties have accepted the plan for proposed partition submitted by partition commissioner, which is marked as annexure L of the report of the commission, and the conveyance deed dated 5th August 2023. In view of the above, the final decree is passed by declaring that the defendant number 3 is entitled to 12.5% of his share, along with shares of the plaintiffs as mentioned in the deed of conveyance, and defendant number 2 to 4 are entitled to 37.5 and 25%. So PS 91 is disposed of. GA is also disposed of. Decree is drawn by making the proposed plan for partition being annexed A to the commissioner's report and the deed of conveyance as part of it. So these are my subjects. So this not basically not this in effect, not makes a partition of the property of the shares of the family. It is affecting partition. 215 is abstract. The other part we have not corrected. We had also charged for the transfer that has been not subsequently. Waived by us after filing of the repeat.
You see paragraph 21 of the judgment?
20. Of the 2009.
Yes, yes. It's Shiv Kumar Bubna. Declaration of shares and rights is part of preliminary decree.
But it could be a joint also. In some
Because-
cases, it can be a joint decree.
Yes,
Preliminary-
but only if, because this explains, a preliminary decree for partition only identifies the properties to be subjected to partition, defines and declares the shares, rights of the parties. That part of the pair relating to actual division by metes and bounds and allotment is left for being completed under the final decree proceedings. Thus, the application for final decree as and when made is considered to be an application in a pending suit. Suit is not disposed of, for granting the relief of division by metes and bounds. Therefore, concept of final decree in a partition suit is different from the concept of final.
Not so, but the judgment also says that there might be cases where when there is no necessity for metes and bounds, parties are separately possessing as per the decree, then the court can pass the composite decree also.
Yes.
Preliminary as well as final. But in this case, preliminary was passed. Subsequently, commissioner was appointed.
And
During that
according to you, the final decree partakes the character of a joint decree.
joint decree because of change of share. But it has both elements: declaration of share as well as effecting.
Very.
These are method.
Malad, my humble submission is this, Malad, so far as final decree is concerned, it should not be treated as an instrument of partition, because it is not the subject matter of the suit, Malad, has not been partitioned. The plan, settlement, and the percentage of shares, everything has been accepted by the party. But the partitions could not be affected, could not be completed because the property was so dilapidated in condition, the partition could not be affected. So therefore, the final decree cannot complete the partition, though they have declared the shares and everything. So as per section 2, subsection 15, Milord, so there was no direction of affecting partition. So it cannot be treated as an instrument of partition, Milord. So no taxes, I mean the is amended, stamp duty is amended. That's my humble submission.
Very good.
The Lordship pointed out that judgment from Lordship's memory. 2009 judgment. That is.
And this judgment is also saying like this. It has to be an instrument, a partition has to be affected to thereafter. And final decree means is like this. My learned friend on the other side, he is submitting that it is a joint decree. It's no. Preliminary decree has been passed long before. Thereafter, partition of commissioners, settlement, partition plan has been drawn up. It has been accepted by both the parties. Shares has been declared, but partition could not be. So it cannot be treated as an instrument. That's my humble submission.
No, his submission is that there is a plan according to which you have accepted how you will arrange your affairs in the property. That also amounts to division of shares, and in that way it is a joint decree.
In that case, my lord, every family settlement would be a partition. That cannot be.
No, this is a decree by court. It's not a family settlement.
Lordship, this is a decree of a court, correct. This is a decree of a court and a final decree. And the declaration of shares has been decided. But the directions of effecting partition is not been there. So partition has not been completed.
Very well, let us see how we go about it.
Family settlement possibly would come in the first part of 250. an instrument whereby the co-owners of any property divide or agree to divide among themselves.
Yes,
Then the second part is the order of.
order of court.
That
Heard
is also instrument of.
learned advocates appearing for the respective parties. Full stop.
Great.
Which item? When it is called on, you give it, I'll give you liberty to correct it. You serve on the correct person. Serve on the correct person, let it come, I'll give you leave to correct. Thank you.